afternoon. The next case is Fore versus Western North Carolina Conference of the United Methodist Church et al., and we will hear from the appellant.
Thank you, Chief Justice Newby, and may it please the court. I'm Lauren Lapidus with Nelson Mullins, here with Gray Wilson, both of the Nelson Mullins Law Firm. On behalf of one of the defendant appellants, the Children's Home, we're here with our colleague, Ashley Catino. She represents the other defendant appellant, in this case, the Western Conference, and she'll present argument after I do. Collectively, though, we'd like to reserve 5 minutes, please, for rebuttal. This appeal before you today involves an extremely overbroad ex parte order with absolutely no guardrails in place that directs the unregulated disclosure of probably some of the most sensitive subject matter that exists in our legal system. This case really does shine the brightest light possible on the danger of North Carolina trial courts treating the entry of ex parte orders as the rule rather than the exception under our North Carolina Rules of Civil Procedure. And also troubling is that the Court of Appeals concluded that there's nothing that can be done about this problem, this legal error, until after final judgment. The Court of Appeals' published opinion should not remain the law of North Carolina. One of the cornerstones of our court system, something that makes it special, protection of the rule of law, ensures that unless there's some type of emergency, both parties get to advocate their position to the trial court on a motion before a court makes a ruling. That's basic, that's fundamental. But that didn't happen below. And all this court needs to do is look at the real and immediate dangers that have been created by allowing the trial court's broad ex parte order entered contrary to GS 7B 2901B2 to stand and to execute. As this state's institutional guardian of the law, this court should ensure that the fundamental principle of the opportunity to be heard in opposition to motions filed in the trial court continues to be honored.
Can I ask you a procedural question before you get to those harms? So, as I understand it, so this is a Mecklenburg County case, am I right about that?
You're right, Your Honor.
But the investigative reports were either in Forsyth County or in Richmond County. Am I right about that?
That's correct.
And when I look at the motion that's filed, it says it's filed under Rule 7, which you can only file if you have some pending civil action. But then it also cites the statute that allows these records that aren't public records to be turned over. And I guess my question is, what would have happened in this case if the plaintiff had gone to Forsyth County or Richmond County, to a Superior Court judge there, and filed either a new civil action or filed a petition and said, we'd like to have a hearing and access these records? Are you contending that if that happened, you, because of this pending lawsuit in Mecklenburg County, would be entitled to notice in that proceeding as well? Or is this all just because it happened to happen in this lawsuit?
I think the key, Justice Teets, is that it all happened in this lawsuit to which we are a party. And I think that's the critical problem, is that when you're a party to a lawsuit in North Carolina under Rule 6D and 5A of our civil procedure rules, the default rule is you get notice and an opportunity to be heard unless there is a statute or rule that specifically authorizes an ex parte procedure.
Can I also just be clear on the facts based on what you just said? I thought that you were served with the motion.
Yes, we were served with the motion.
So you had that notice, and there was no hearing. The court just ruled on the motion without letting anybody know that it was about to rule, right?
That's correct, Justice.
And so why couldn't you? And assuming we agree that that process, what the trial court did there, violated GS 7B-2901 because that statute gives Departments of Social Services the opportunity to come in and be heard when confidential records are being requested. Assuming that what the trial court did there was not consistent with the statute, what stopped you from just filing a motion with the trial court saying, wait a minute, hold on, we should have a hearing, we should be heard, Social Services needs to be heard, and giving the trial court the first opportunity to correct its error?
Just so I'm really glad you asked that question, because my next point was to say, we ordinarily don't talk about facts, but there's really something that I'd really like to clarify for the court, and it goes right to what you're saying.
Okay.
And I think I'm going to articulate a timeline for the court that's going to explain why that was not a viable a realistic option. And here are the reasons. The ex parte order was entered on 11 June 2021. That's at record page 48. So the motion was filed a week prior, and an ex parte order just comes back in the mail a couple days later. It's record page 48. Then there was a relative period where we were trying to figure out and study what to do. And then what happened on 30 June 2021, when plaintiff's counsel, without notice or consultation, began to actually take direct steps to enforce the ex parte order. And that is located in attachment 10 to the plaintiff's motion to dismiss our appeal based on various grounds. It's not part of the record on appeal in this case, but it is, for the court's reference, I suppose, attached to the motion to dismiss, attachment number 10. And what attachment number 10 did is it sent a copy of this ex parte order to these various Richmond County and Forsyth County agencies with a cover letter that quoted the broad language of directing the disclosure and telling these agencies, the court has directed you to produce them, produce them.
But you were served with a copy of the order.
Correct.
And so what stopped you from the next day going to the court and saying, whoa, wait a minute, hold on, you can't order this, we haven't been heard?
Oh, I think the answer to that is relatively straightforward in that a motion for reconsideration in North Carolina does not toll your appeal period. So that would have been extremely dangerous position for us to do, particularly in Mecklenburg County, right? Justice Earls, the practical realities in Mecklenburg are something that the court should be aware of. When you want to get a hearing in Mecklenburg, it takes several weeks. We've been involved in many Mecklenburg cases, and that time delay between the ability to actually get anything done, the appeal period would have already ended. So what happened here is that you have these letters that were sent to the trial court saying, give us these documents. And these enforcement efforts required prompt action by our clients. So we filed a notice of appeal of the ex parte order on 2 July 2021. We then filed a motion for a temporary stay and a petition for writ of supersedious with the Court of Appeals on 8 July 2021, and the Court of Appeals allowed the temporary stay on 11 July 2021, a couple days later. This now, I guess, brings us to perhaps your follow-up question, Justice Earls, which is, well, what appears on record supplement page 4, which is plaintiff's 12 July 2021 letter offering to effectively join a motion for reconsideration to undo all this. But of course, that correspondence does not present a viable course or alternative at this point because the defendant's notice of appeal was already filed, and defendants would have been required to withdraw the appeal that they had taken, and with it, the temporary stay that the Court of Appeals gave on these documents, that if they came out, the stigma that is associated with these documents would be unfathomable and intolerable, and certainly nothing that can be fixed after final judgment. So this sort of odd-timed offer after trying to execute and then filing our notice of appeal and receiving a stay failed to present at that time, Justice Earls, really a jurisdictionally viable or safe alternative to ensure that this ex parte order was corrected at the earliest possible opportunity and the most jurisdictionally proper opportunity. Thus, on this record, with this factual clarification, the Children's Home respectfully requests that this court reverse the Court of Appeals majority opinion, conclude that defendants have satisfied the substantial right test to take an immediate interlocutory appeal, and also reverse the trial court's erroneous order entered contrary to 7B 2901B2 and remand with instructions to conduct a proper contested hearing with notice. Now to address the core legal issue before the court, which is, of course, whether defendants met the substantial right test to support their interlocutory appeal, which is, of course, decided on a case-by-case basis. Here, we would contend that substantial rights test was met. For these reasons, we have shown a material right worthy of protection by North Carolina law. This goes, Justice East, to your question. Statutory rights of a party under North Carolina Rules of Civil Procedure 5A and 6D to receive an opportunity to be heard in opposition to motion filed in a case by an opposing party. These are material rights which this court and the Court of Appeals have long recognized. This is nothing new. This is bedrock fundamental North Carolina law. In 1979, this court in Craver versus Craver, citing a Court of Appeals opinion in Pask versus Corbett, said this. This is the quote from the case that this court adopted. It should be beyond question that the right to notice and an opportunity to be heard on motions in a lawsuit is critically important to the non-movement. its omission by the court cannot be considered of little consequence.
But let me, and I'm being very generous to the Court of Appeals majority because I don't see this opinion as like a paradigm of the appellate jurisprudence here, but what if this is essentially their reasoning, is that on questions like privilege or work product, you can sort of analogize the material here, because the idea would be once it's released, you can't unring the bell. So right now, the plaintiffs don't have a right to just go and look at it, but once the court order is entered and it's turned over, even if they later say you can't use this at trial or something, let's say, it's like privilege where, yes, but they know what they saw and they can't unsee it. But that principle of, in attorney-client privilege and other areas applies because the other party would have the ability to go in and say, don't disclose it. I understand that the Court of Appeals here may have been saying, but even if you showed up at the hearing, you don't have any right to be heard. So you're not one of the parties whose voice really matters, and so what difference would it make to you if you'd been there? So what's your response?
I understand, Justice Dietz. And, to that question about essentially were you prejudiced by the failure to have a hearing, the Children's Home rejects that analysis for these reasons. There is no prejudice analysis in the right to be heard in a motion in North Carolina. There is no substantive pre-clearance requirement that the court, on a motion properly filed in the trial court where you get a hearing, sort of does a checkoff to say, do you have a minimum meritorious threshold argument to make? But even if you're asking, well, what was important to tell the trial court? What was important to tell the trial court is that the Children's Home, as the potential, to the extent these records exist, right? Not just, this record was incredibly broad. So it's not just former employees, but it's current ones too, right? So there's a legal employee-employer relationship potentially here. So what we needed to tell the court is there needed to be critical guardrails put in place that were not put in place that would govern the conditions of such disclosure. So what do I mean by that? Time and scope restrictions on searches, naming people whose records are to be searched as opposed to what the order says, all employees of the Children's Home. In-camera review requests, the timing of release to the defense counsel, appropriate redactions, confidentiality to provisions, attorney's eyes only. For example, Justice Dietz, with this order, there is absolutely nothing, if it were to execute, that could not be distributed to the New York Times or WRAL, whatever documents were obtained. And that would create an immeasurable stigma for so many different parties, victims, third parties, I think the other real trouble here is these are not records of convictions. These are records of allegations, unsubstantiated allegations, okay? So I think a trial court really has to be much more careful when it deals with records of allegations with such a sensitive subject matter. So the stigma that would be associated with, and that this court recognized in Ray AK, that there's a stigma associated with, if these records came out to the extent they exist, that immeasurable and irremediable reputational and stigmatic harm to the Children's Home in the community and in the state.
But I think the point is, these were not your records, right? These are, they were seeking records from Sheriff's Department, the Richmond County Juvenile Division, Forsyth County Department of Social Services. These were other parties' records who do have a statutory obligation to protect the confidential information that you are talking about, right? And so why wouldn't it be their burden to come to court and say, you've ordered us, Your Honor, you've ordered us to produce this, but we have a statutory requirement to protect confidentiality, and we need a protective order. We need to make sure only the attorneys see them. We need to do the redact. Like, why isn't that under our laws? That's for the Social Services Department to do.
I think that, Justice Earls, your position is reasonable, that they have a duty too, but that does not discount our right as a party in a case filed in Superior Court under our rules of civil procedure to get an opportunity to be heard in opposition to a motion. Imagine what would happen in North Carolina if the majority's opinion below was followed, right? What the majority opinion below said is, as long as a statute does not prohibit an ex parte procedure, then it's allowed. But that flies in the face of the text and structure of our rules of civil procedure and our statutes. So these two statutes that are at issue here today, 132-4.1 and 7B2901, those don't allow for an ex parte procedure. Now, Justice Earls, I'm not saying that you can never have an ex parte procedure in North Carolina. In fact, there are good reasons to have them, but let's look at the instances when you do. There really are two categories on each side of the bell curve, right? So you have emergencies, temporary restraining orders, claim and delivery, attachments, temporary domestic violence protective orders, and then on the other side of the bell curve you have, like, this court promulgates appellate rules that say, if you want to get an extension of time to serve the proposed record on appeal for 30 days, you can ask the trial court without giving the other side any notice, and that's fine too. But I think,
You did have notice here.
but no opportunity to be heard. And I think that's a critical component of our statutory rules of civil procedure, that you will have, I think, a system that if it's solely in the discretion of the trial judge to decide in any given case whether there's going to be a hearing or not, when Rule 6D and 5A presuppose that it is. I mean, we talked about earlier, Justice Allen, when the General Assembly wants to be pretty specific about something, it does. But when you look at all of our statutes, when there's an ex parte procedure for a motion that's authorized, the General Assembly says so in black and white, clear as a bell. I mean, here it's nothing. If you would leave to the trial judge in every single case, the system of opportunity to be heard would be arbitrary. The trial court would say, okay, well, this one we will have a hearing, but this one we won't, and no one will be able to know why or how. So Justice Charles, to swing back to your question is, as a party in a case in North Carolina, you have a statutory right under the rules of civil procedure to be heard in opposition to one, unless there is a North Carolina statute or court rule that says that an ex parte procedure is allowed. These two statutes do not allow for an ex parte procedure to be allowed, so therefore it was important and critical and unlawful for us not to receive one. And also the reasons why I said, like, if these documents were to come out, the kind of stigma attached, not just with the children's home as an employer in the community, but think about the victims and the third parties. I mean, we don't know what's in there. Not a single Superior Court judge looked at a single record in camera, and you have an incredibly broad ex parte order that just completely releases this to the extent they exist, right? So, I mean, that is incredibly dangerous. So I think our right to be heard comes from our rules of civil procedure and from our statutes. And we needed to ask for those guardrails to be put in place so we wouldn't be in the position that we are today.
You know the offer that your friend made after you'd appealed that said, hey, what if we just try to go to the court and, if your friend was still willing to do that, would you oppose this court just vacating the Court of Appeals and remanding for the trial court to ensure that social services and anyone else who has a statutory right to be heard can be heard?
I think that would be just fine, Justice Dietz, because this court would be respecting that the rules of civil procedure give you a right to be heard, and those guardrails that needed to be put in place can be put in place. And that's in the best interest of the parties, the victims, any third parties mentioned in those records, and the public. So yes, I think that would be suitable. And alternatively, a means for us to get immediate appellate review and discuss in the dissent just briefly is a statutory privilege argument that sits there under this court's opinion in Sharp. I just want to set that out there, that we did assert a non-frivolous statutory privilege that directly relates to the matter to be disclosed. And even though the statute is silent on whether a party who doesn't hold the records could assert it for the reasons stated in the dissent, we think we could, because there's a common public interest which would effectuate the purpose of the statute. So I think we have an immediate right to an interlocutory appeal. We met the substantial right test. We've shown a critical right, one that this court recognized in Craver versus Craver, and one that the Court of Appeals has recognized in Pask versus Corbett, long-standing ones. So the next step to the analysis, of course, is there reversible error? And the answer to that question, we think, is yes. And these are the reasons why we would ask the court to vacate or reverse. Number one, Chapter 7B, 2901B2, requires that DSS be invited to a seat at the table. In fact, the statute prohibits, as a matter of law, entry of an order releasing such protected alleged child abuse records unless and until DSS is properly alerted, and we know that didn't happen here. Reason number two, the statute 7B 2901B2 requires the trial court make a determination that the information sought was unavailable from any source. If you look at the text of the order, there is absolutely no finding made in this order that the material was unavailable from any other source. Error number 3, the ex parte order contains no findings regarding the existence of PHI protected by federal law ordering the release, but such determination necessarily can't be made unless there was an in-camera review in the first place, which shows how the trial court here put the cart before the horse and didn't do its job under this statute, which is to protect these very sensitive allegations and records to make sure this doesn't happen. So for these reasons, in addition to concluding that we had met the substantial right test, this court applying de novo review, giving no deference to what happened below on this purely legal question, should also reverse the Court of Appeals ex parte order on its merits and remand the cause to Superior Court for a hearing where both defendants and DSS can receive notice of the hearing prior to any subsequent order on entry of any other motion. Stand ready for any questions before I yield the rest of my time to my friend for the conference, Ms. Catino. Thank you.
Counsel?
May it please the court, my name is Ashley Cutno. I'm with Ogletree Deacons, and I represent the Western North Carolina Conference of the United Methodist Church. And I will be very brief and just make a very quick point. And I think it goes to 2 direct questions by Justice Earle and Justice Dietz that were raised here. In many of the cases you have like this, you're looking at what are the parade of horribles that could happen, but my client was in a very different position. When this motion was filed, we had pending a 12B1 jurisdictional argument that no discovery could be done until we determined if the court had jurisdiction over the Methodist Conference. Our reply, Justice Dietz, had we been able to file one, would have re-raised the 12B1 argument and said no discovery can be done outside of the 12B1 context. But again, Justice Earls, I think this goes to one point you raised, the timing was so short. The motion was sent on June 3rd. The order was issued on June 11th. We're talking about less than a week for us to have reacted and raised those arguments when in the normal course and process, it would have been some period of time. We would have known the hearing was coming. We would have had the ability to properly brief those issues. And of course, a 12B1 argument, which we have noted in the briefs on page 4 in the main and in footnote 2 in the reply, is of course a substantive right that has to be raised. It was raised in the initial motions. That was not something that was brought to the court's attention when plaintiff filed the motion. And because it was ruled on so quickly, the conference did not have the ability to raise that issue and create the proper record on appeal to be able to fully argue that piece of it. So you do see, from my client's perspective, a different position and a real substantive right that would have been raised had we had the opportunity to be heard and for it to be addressed, which I think, Justice Dietz, is one of the questions that you have, and that would have been my answer to the question, was that what I would have stood up before the trial court and said is we have a 12B1 issue that must be resolved to determine if the court has jurisdiction to issue anything at all in this case before that can be done. Thank you. And we'll reserve the time for rebuttal.
Thank you, counsel. Hear from the appellee.
Good afternoon, Chief Justice, Associate Justices. My name is Matthew White, and this is my co-counsel, Richard Serbin, and we represent the plaintiff, Lisa Biggs Fore. And while it's an honor to be here arguing in front of you all today, unfortunately, this appeal is nothing more than an egregious waste of this court's time. It has been 39 months and 8 days since the underlying order in question was signed. That's over 3 years of incredible expenses incurred on the plaintiff, the time and the resources of this court, as well as the Court of Appeals, the entire appellate system, and all over an interlocutory issue that could have and should have been addressed at the trial court level first. And it could have been in 2 readily available ways. First of all, they could have gone our friends here could have gone to the trial court directly and filed a motion to vacate or a motion to set aside the order pending a hearing. Or we tried to make it as easy as possible and offered to join a consent motion to vacate the order and request a hearing. And
So I gather, based on that offer that you made, that you acknowledge that at a minimum, the Department of Social Services should have had a chance to respond to the trial court before the court entered the order.
I
Do you
think
agree with that?
we think that it's unclear whether the trial court made a simple clerical error or if they intentionally signed this order and granted the motion without a hearing. And that raises the problematic issue of us being here today, is we don't know whether it was an intentional act or whether the trial court made a simple, correctable mistake.
Well, you heard your answer from your friend. I mean, what if we vacated the Court of Appeals, sent it back with instructions for the trial court to hold the hearing, because there's a statutory mandate that DSS had a right to at least respond before entry of the order, and of course, you'd be free to stand up and say, Your Honor, now the defendants are trying to talk, but they don't have any business talking here. This is between us, maybe DSS and you, about release of the, I mean, would you have an objection to that?
The end result, no. But the fear is, so they want to talk about this universe of all this flood of records that we're requesting and disseminating. But the real fear from our perspective is that setting a binding precedent that's going to affect future litigants in this state forever, for years to come, and it's going to affect not only future litigants, it's going to affect future parties and non-parties under 2 statutes, and it's that's the main danger, I think, with issuing a ruling and an opinion on what they claim are the substantive issues.
But if we were merely to vacate the Court of Appeal opinion, then that wouldn't raise the concern you're
Right, as long as the facts, or not the facts, but there's no kind of binding precedent in terms of, because, if they had, let's say they had filed a motion to vacate or a motion to set aside the order with the trial court, and the trial court declined it, they said no, then I think they might have an argument. Right now, I don't even think there's an argument, but I think they might have an argument, but I think there are arguments against that argument as well.
And what's your response to what I understand their position to be, that they had to file their notice of appeal because there was no time to seek to file any motion and get a hearing on it, and by filing the notice of appeal, that then divested the trial court of any ability to do anything?
Thank you for asking that, because I wanted to clear up, and this is, in other words, some of the underpinning factual issues. Yes, the order was signed June 11th. That's not when we all found out that the order was signed. It was a couple of weeks after that date that we surprisingly got the signed order in the mail. It was June 30th when we emailed the order to the subject public law enforcement agencies as well as to defendants. June 30th is when we learned that they had not been served and that they didn't know that that order had been signed and issued. So because there's...
So did the court sign, this is one thing I wasn't clear on, was this an order that the party said that you had drafted and that was there and the court signed it? Is that what happened? So it was
Yeah.
sort of maybe when you said there was maybe an error, you're saying perhaps the court not fully understanding or not quite remembering thought maybe I'd handled this already and maybe signed this draft order not realizing I didn't even let the parties argue. Is that
That's
your position?
exactly right.
Yeah.
And I think that's a very real possibility. And so June 30th is when we all learned that, there might be an issue. July 2nd, less than 2 days later, they filed a notice of appeal. It said that they needed to take time to study what to do. They didn't take a whole lot of time to study what to do. They just fired an appeal down. Meanwhile, 3 years have gone by, and this is not discovery. We're not seeking records from the defendants. But this is not technically a discovery issue. It's not, we're not asking the court to compel them to provide us anything. This is a document request issue to third-party public agencies. And when that's the case, for over 70 years, this court has held, if there's a perceived error that can be corrected by the trial court, then you're supposed to go to them first and allow them the opportunity to correct their mistake. In Collins versus North Carolina State Highway and Public Works, a case that they cite to support their argument, states as follows, that this rule is based on sound reason, to furnish an expeditious and inexpensive method by which courts of first instance may correct their own lapses from procedural irregularity. So it lays out some policy reasons, including to fully develop the record and avoid premature appeals, and to preserve a judicial economy and avoid unnecessary delays.
You don't disagree that a motion to reconsider or that does not toll the time to appeal?
I can't say that I disagree or that I agree. I don't know, but I'm happy to do further research on that if you'd like me to. I just don't think it's at that level that an appeal is appropriate. The record wasn't fully developed. We don't know why the trial court did it. We can't, how can an appellate court pass judgment on something that the trial court did when we don't know whether they intentionally did it or if it was just a simple mistake? And why?
Well, the fact that it was done, regardless of the motivation, it was done, and the question is there a statute or rules that require that it not be done without a hearing, right? Isn't that really the issue?
Yes, that's certainly the issue. But I think from our perspective, the real issue is, what do you do first if there's a perceived mistake by the trial court?
If you don't have a guarantee that the trial court will rule within the time to appeal, what other alternative does a party have other than to appeal?
Well,
again, it gets back to the question that you said you didn't know the answer to, which was whether this motion to reconsider would toll the time to file an appeal.
right. And it also, I think that kind of gets down a layer deeper into whether they would have had a right to appeal this anyways, right? They're substantial rights arguments that somehow we violated Rule 5A, and that's a basis for a violation of their substantial right.
Part of what I think this court is struggling with is that from the perspective of the Department of Social Services,
Yeah.
they certainly would have had a substantial right that would have justified the appeal, because they would say, we might have been able to stop some of these records that we just really thought shouldn't be released from being released, and we just didn't even really get a chance to be heard. That makes this court uncomfortable, because that's a statutory mandate that was clearly violated in this case. So I think we're searching for a way to still give you the opportunity to make the arguments you're making, but not have this opinion on the record that is completely inconsistent with that law, as the dissent points out. So I think that's why we're sort of seeking a solution that doesn't prejudice you, doesn't prejudice the defendant either. And it sounds like you might be open to vacation that makes clear you can make the same arguments you're making to us about how they don't really have any rights here and that sort of thing to a trial court in the hearing.
Yes, again, in the end result, yes, exactly. But in this case, they're acting as if the Department of Social Services just has no agency, that they're just this, but take an order and I go in and just start taking, I mean, they have the legal duty, they have the legal right, and they can exercise that right. They don't need third-party litigants in a random civil case to enforce their rights or to step in and fulfill their obligations. So what is the right? Is it substantial? And was any injury relying on this appeal in order to be stopped? Or could it have just been taken up with the trial court first? And that's really the bottom. I mean, that's the heart of our argument, is that this is an unnecessary appeal. This goes to the entire purpose of this court disfavoring taking interlocutory appeals. Anytime some kind of issue when it comes to discovery or a document release or any kind of interlocutory issue, you know, there are the rules, and then there's the kind of the business of the practice of law, right? If something happens, the first resort should not be the appellate court if it's an interlocutory issue. This should be the last resort where, hey, there's a very substantial right here that's being threatened, and if I don't appeal it right now, then that could be lost. That's not the case here. There is no right that could be lost, and not only was there no substantial right shown, which is their burden to show, that there was no right, certainly no substantial right. They were not reliant on this court in order to redress what they perceived to be an error by the trial court. And so I think that, you know, that addresses both the substantial right as well as the statutory privilege arguments. The statutory privilege, if it's not a direct, you know, the rule is if it's not a direct injury, you have to be in the class of persons the statute is intended to protect. This statute is intended to protect the Department of Social Services, alleged child abusers, and victims of child abuse, ostensibly. Not random litigants in a civil case. So I think just from a practical policy standpoint, a legal standpoint, however we get there, I just would respectfully request that this court does not use this case to influence how these things are interpreted in the future that could affect future litigants in this state going forward. And if y'all have any more questions, I'm happy to answer them. If not, we respectfully request that you uphold the Court of Appeals and dismiss this unnecessary interlocutory appeal. Thank you.
Thank you, counsel. Rebuttal.
Chief Justice Newby, to your point, there was no option but to appeal, and my friend for the plaintiff made that abundantly clear when he explained that the order didn't get sent until June 30th, and that's the exact date. The date that the plaintiff received that order, they sent it out to all those agencies that day, which required an immediate appeal and a motion for temporary stay. That's the appropriate thing to do. And Justice Dietz, to your question, when you're discussing these issues to my friend for the plaintiff about essentially standing, I think is what you were talking about. And I think our point is that the North Carolina Rules of Civil Procedure give us the right and opportunity to be heard at that hearing and make the argument as to why we should have a say in the matter, and the trial court is free to accept or reject that. But what this is not is a subpoena. right? And I think that, Justice Dietz, is really important, because in a subpoena context, you have basically different procedures set forth by statute, right? And then if you're a party, you have to show some type of privilege or personal right. But this is not a subpoena. This is a motion in the cause, right? A motion in the cause where we, under our rules, unless there's a statute or a rule that says you don't get to be heard, we have a right to be there and be heard. Because then you'll have a chaotic and arbitrary system that would be intolerable. So the fact that it's a motion, I think, is important.
In the absence of the lawsuit, in the absence of the litigation that's underway, would you be entitled to notice under the disclosure statute?
Well, Justice Berger, it depends on how that procedure was brought up. Are they going to file a brand-new lawsuit in another county and not make us a party to it? I mean, that's their prerogative, and I suppose if we're not a party, right, because my argument today is that if we're a party in a lawsuit, we get a right to be heard, so I suppose there could be a situation where they come up with some type of procedural vehicle or some type of booster rocket to get what they want that doesn't involve us, then that could potentially be a different question. But here, we're unquestionably parties to the lawsuit where they filed a motion in the cause. And the final point I want to address is this court's 1953 opinion in Collins, because I think what you heard from my friend for the plaintiff is, well, we had to come and ask the trial court to fix it. But here's the trouble, and this is a really critical distinction in Collins. Collins, by its plain text and holding, applies to irregular judgments. Irregular judgments. Irregular judgments are ones that are provided contrary to recognized methods of practice and procedure, right? But here, the challenged order is not merely just irregular, it is erroneous, right? It constitutes, for the reasons I articulated, reversible prejudicial error for misapplying 7B2901B2. And only appellate courts correct legal error, not trial courts. Thank you.
Thank you, counsel. Thank you, everyone. Mr. Clerk.